Some viewers may find the following video disturbing. Viewer discretion is advised.
Well, hello and welcome back to the channel, everybody. In today's video, we are going to take a look at the video recently released by Patrick Darcy as he examines Chille's most recent lawsuit or LOL suit. Now, please keep in mind that Chille claims to be a 20-year constitutional law scholar. Now, is he really a 20-year constitutional law scholar? Well, that's definitely going to be one of the questions that may be answered in this video. So without further ado, let's go ahead and get this freaking S-show on the road, shall we?
Hello, everyone. It's a preview of the Chille lawsuit against the judges and Agnes, the prosecutor, the bailiff, and even the judge that reversed his conviction, Judge Levitt. She got sued too.
Yeah, talk about gratitude. Sue the person that got you out of hot water to begin with. I mean, come on, Chille. That's low, very low. That's like a kid going up to his dad and punching him in the balls after he reversed a punishment decision made by the mother. Yeah, that kind of business. I mean, just ridiculous. But hey, that's fraudulent life for you. Bite the hand that helps you out.
There's so much here that there's no way to make this into a fast video without cutting corners. So we'll let the people who are getting paid work on the case. But let's take a look. First of all, behind me, of course, is my fuck around and find out graph. And it shows on the x-axis here that the more you fuck around, the more you're going to find out based on the equation y equals mx plus b. For those of you who haven't forgotten or were actually paying attention in school, that is the algebraic equation for a line. And I showed that for Andy Kaufman, he has a higher B value because he's more annoying than, say, Spalding from Caddyshack. So let's take a look at this lawsuit. It is got a lot of stuff going on to it, a lot. First amended complaint for damages, so we can't amend any further without leave or without permission from everyone with the stipulation. 1983 cases are powerful because they include attorney's fees clauses, but you have to usually have your own lawyer. And if Chille's representing himself pro se, I'm not sure that he gets attorney's fees for that. I'm not a 1983 lawyer that's in the civil rights arena. I don't handle those cases. But normally, if you represent yourself, you don't get attorney's fees.
What? Well, maybe Chille thinks he's something special and he can get attorney's fees or some shit like that. Hell, his brain is so heavily rotted from all those years of eating that lead-laced Play-Doh from when he was a kid. Yeah, that stuff will really do it to you, so you might want to be careful. But that's the old Play-Doh from many, many, many years ago. Now it's completely safe.
Putting aside the typos and shit, there is a rule that you have to serve, name the Clark County, Nevada as part of the case. And Zimmerman, now in her situation, and we'll talk about it, you know, there is different types of immunity for her. This is an immunity case. Does Ann Zimmerman have immunity? Does Agnes have immunity? The same for Judge Levitt, who, by the way, is the most appealed judge in Nevada. Bork again is back in the picture. And then the bailiff that Chille did not like, he's named too.
Say what?
When you're looking at the district attorney and you're looking at liability for them, there's two essential categories that you have to look at. One is absolute immunity, such as arguing in court, making oral argument, and things like that. Anything that's advocacy, she gets absolute immunity.
Well, gee, I just can't imagine why somebody would get immunity in this particular case. Yeah, it's not like there are two sides or more to every single argument out there, and every side has to be listened to in order for it to be fair. Nah, that couldn't be it. But in some cases, fairness to certain boneheads is a four-letter word, and therefore they've got to sue the prosecutor because, well, fairness is not exactly in their vocabulary.
Then there's qualified immunity, which comes under the reasonable prosecutor standard, which is more factually intensive and a lot more difficult to hash out. And it helps Chille because it makes it more difficult to dismiss the case on 12b6 grounds because there'll be factual disputes. Now, remember something, a factual dispute is no longer a factual dispute when both sides admit to it. Then it becomes a pure question of law, and a judge can rule on that. Next here is, here's where areas where a prosecutor can get in trouble: press conferences, illegal search, evidence destruction, decisions on whether or not to follow a witness, things that go outside the actual advocacy function of a prosecutor. Then there's no need to say material perjury. Perjury, at least under Penal Code Section 118 here in California, is a false statement of fact that is material. Here's an issue that I found, at least for me: the exhibits that he looked at, almost all of them except for one, wasn't attached. In California, again, using California as an example, part of the Ninth Circuit, and I'm certain the laws are the same in federal court, if you make reference to attachments, those attachments can override your conflicting allegations. In state court, that would be the Meade decision. Pay attention, state court. There were new videos. Well, 2018 isn't new to me. This is parallel to what we call a motion for reconsideration type of situation where there's a change in law, change in circumstances, newly discovered evidence, whatever, that could not be discovered under reasonable circumstances. 2018 doesn't seem to catch it to me and get there. Bork's perjured testimony, a lot of conclusory statements within this complaint. I think what Chille was trying to do, and by the way, there are areas where Chille's pleading is getting better. It's not like it's great, but it doesn't have to be great. This is just the initial foray into the mess.
So his legal writings are getting better. It kind of makes you wonder, had he actually had 20 years of practice as he claims he has had, 20 years of being a constitutional law scholar, don't you think all this would have been improved, well, at least 15 years ago? So it really just goes to prove that if he's only just now starting to improve in his pleadings, then just maybe, he's been grifting this whole time, not really being truthful as far as being a constitutional law scholar for 20 plus years. Yeah, really think about that. Take a moment and think about that.
But he also, I think, is trying to comply with Rule 8 with a short, plain statement of the case, so I get that. And then he's probably waiting for the attack challenges to come, and then he would know how to amend. So therefore, that might be what he's trying to do here. But there's a lot of just conclusions, and conclusions or argumentative statements do not meet the pleading requirements, either in federal or state court. So ARG is argumentative. Okay, these are facts, as long as it supports the claim. Here, the Mack decision is really important. 2022 case, Nevada Supreme Court was asked to certify a question from the federal district court in Nevada, because there's only one district court in Nevada. The person came to visit an inmate. They were illegally strip searched. There was no drugs on them. Then they were interrogated, and they found out that there was no remedy for them. So the state of Nevada said, you know what, this is a violation of our rights as citizens under the state constitution, and therefore there will be a remedy for this. And, in some ways, Chille might be arguing that. Or he'll make claims under the Nevada Constitution. When you get to the, sorry, I'm trying to go as fast as I can. Agnes, the main case that dealt with this was the Imbler decision in 1976, U.S. Supreme Court case. And I'm sure there's others since then. I was looking at them. There was one in 1982, the Washoe County case. Here, Nevada has a statutory immunity that they're for government employees. There's also a waiver of some of that immunity for the prosecutor, absolutely is qualified, bail hearings, advocacy function. Those are all, so let's look at what Chille is actually saying she did wrong. More conclusory things, same thing has been repeated. These exhibits weren't attached that I found. Anyway, material, we don't need to say that. Here, Chille made a statement that was rather broad. I pulled it up. The exhibit is 51 pages long. It's a very lengthy ruling by the judge on his claims for most of her summary judgment, reconsideration of some of that, which was a wise move by Chille. And there were some changes in the judge's ruling because he was now acquitted of those two charges. But what's interesting is what the judge said. Judge had found that there was probable cause for Bork to arrest. And then when the state judge, the one that's been appealed in, more than any judge in Nevada, who clearly didn't know the case, Remember, he lost on 4 of the 5 grounds, but the one that he won on was the one that was the most outlandish of all. It wasn't a First Amendment case. No one ever said it was, but that's what got you there, because you had a prosecutor at the appellate level doing nothing, not even arguing the Wilson exception, not even showing the actual tape.
Well, it was a shit show all the way around, because you ended up with a district attorney in this case that probably didn't have time to set up an argument or anything like that. Hell, probably didn't even know the video existed until later. What I would assume, piss poor preparation. When you deal with any challenge in life, you should always go with the 6 Ps. Proper planning prevents piss poor performance.
And by the way, for those of you who are stuck in this mantra that Chille backed up and they didn't know how far to back up, and therefore, under this fiction, he did not do anything wrong, you are ignoring the statements in that 51-page ruling, which I've already looked at, which anyone can look at the tape and see. There are times when Chille says, no, I'm standing right here. That's obstruction. So if they played the videotape, he loses, okay? This judge wasn't fooled. This judge even used Chille's own pleading against Chille and found that he had obstructed. Now the judge is trying to say, well, if the state court had a different decision, it's reasonable, but there are other reasonable interpretations. So the judge is saying, I'm not wrong, just like I'm not wrong. And for those of you blaming me for, oh, you got it wrong, listen, I didn't argue the case, okay? I'm just sitting there watching it. There was more than enough ways to win that case. Okay, so I made a mention here. The judge said that Bork acted with probable cause and didn't have the benefit of the Wilson decision, which, of course, in Chille's win, they misspell it, and Orem left out the exception to Wilson that would have convicted him, which is if you act passive aggressively, if you act with an intent of noncompliance, that is a physical act. So when Chille says, no, I'm standing right here, that's a physical act.
And think about that little tidbit right there. When you hear frauditors say that interference is a physical act, but they have no way to prove it. They always say that. But this particular statement right here says that even non-compliance can be considered a physical act, which is essentially true because you are physically not moving your body away from the scene, so therefore it does become physical. But hey, frauditors, if you want to continue to argue that point and make yourself look even dumber, well, be my guest. But just remember, you may not have a legal leg to stand on at that point.
That federal judge wasn't fooled by it. So there you go. Anyway, but that doesn't mean that he was entitled to a 6-month sentence. That's ridiculous. And he makes some good arguments here, Chille does, because we can't prove it, but it certainly seems like the judge took it out on him when he was provoking her at sentencing. That's what it sounded like. Okay. Judge Zimmerman demonstrated bias by denying plaintiff's scheduling requests while granting identical requests from Officer Bork. Conclusory, but there's some stuff here. But now, let's look at immunity for a judge. If it's from the bench, at least here in California, it's pretty much, there's immunity. You're protected. But there's also situations where a judge makes administrative decisions. So, for example, when a judge is involved in making an employment decision, that's not from the bench. Therefore, there is less protection. Here, Judge Zimmerman ordered bailiffs to search plaintiff despite his clearing courthouse security. That's from the bench. In California, that would be fully immune.
Gotcha, bitch.
Also, you didn't disqualify her. In California, the steps to disqualify a judge is a 170.6 petition, has to be timely. The search was ordered solely to prevent plaintiff recording court proceedings. Well, if there was no if the court would not allow recording because there's a rule, and the rule is like Nevada judges, you have to file a request, then that's the rule. So what?
Whoa, 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 whoa.
But Patrick, didn't you know the old argument that it goes against their First Amendment rights to be disallowed to film inside of a courthouse even though the judge has authority within that building? Oh, no, you didn't hear that? Well, maybe you should watch some other frauditor videos like Dumbass Elmo, aka Auditing America, where he tries to convince certain bailiffs to rebel against the judges because he believes they don't have any authority within that building. He's tried it several times, but it's completely blown up in his face.
Also, when you enter the facility, it is a controlled facility, and I'm sure there are signs in the front that say that you consent to being searched. So good luck with that. Yeah, I would say that Chille calling the bailiff a pig would be expression that could be protected, but context always matters. If the judge says, and I would agree with her, that that's contempt because of the way you're using it, you're showing disrespect in front of her, then contemptuous speech, which she warned him could be contempt, is not protected. You don't get First Amendment protection for that. This is a good fact. This is a great fact. You know, is he the only one that she ever sentenced to all this time? That would beg the question, why? And not attached, but that would be a great fact for him. At the initial sentencing hearing, Deputy District Attorney Agnes recommended a suspended sentence. Now, this is advocacy, so there would normally be full protection for this. Then reversing her position, she's allowed to do that. Judge Levitt arbitrarily vacated the bond hearing. Not so fast on that one. First of all, that's from the bench. So normally in California, and it's part of the Ninth Circuit in Nevada, that would be full immunity. And remember something. Judge Orem submitted the same exact 4-page quote unquote motion that cited to one irrelevant case to Levitt that he gave to Zimmerman. Judge looks at it, has a hearing, and looks at it and says, this is a piece of shit motion. It's not doing anything for me. It doesn't even have any relevance. Comes now. Yeah, you know what? It's within her discretion to turn it down. She has discretion. And discretion is a very wide tool. It can only really be overturned when there's an abuse of discretion, which would be beyond the bounds of reason. Okay? And remember, the one you're accusing of misconduct is the same one who gave you the win. So good luck with that. Excluding plaintiff supporters from public proceedings. Well, was there anything in there that would have caused them to want to do this? For example, too much pretrial publicity. Were people, and I don't know that they did this, were people calling the courthouse and call flooding? I heard about it. I'm not saying that Chille did it, but were the supporters becoming, an issue, right? I don't know the reasons, but that can always be a reason, no matter who it is. Judges have the power to take control over their courtroom.
A bullshit? A bullshit? A bullshit? A bullshit?
Again, Patrick, you need to see Enrique Alonso Torres versus nobody to see that you are completely wrong in this situation, according to defense attorney Enrique Alonso Torres, that judges have absolutely no authority within any courthouse whatsoever. Now, where did Torres get this bullshit claim from that judges have no authority in their courthouses? Well, funnily enough, do you smell that rather rancid aroma coming from the claim? Well, it's called bullshit, and it came right out of his ass.
Evidence establishes Clark County maintained policy and practice violating constitutional rights. I think I remember Chille actually complimenting Clark County detention officers for treating him nicely. Now, maybe that was that one time, but I have a feeling they're going to dig up that video. Court found plaintiff's conduct was protected First Amendment activity and reverses conviction. Not exactly an accurate statement. You lost on all the other ones. And if we're to be real here, what you briefed in your appeal wasn't accurate at all. I mean, in a real appellate situation, that would have not even seen the light of day. Appellate court would say, I'm not making your arguments for you. What exact speech did you say that was impinged? The judge said at the trial court level that you had a right to film. The cop said, when he was detaining you, you had a right to film. Then when you get to the cop, more questions about immunity. And for Chille, the good decision for him was the one that came down in 2022, the Mack decision, which basically said, hey, you know what? Maybe there are grounds here where a police officer needs to be more accountable. So that's going to help him, And the judge did mention that in his 51-page opinion. The Mack decision is right here. This is a very important case where they basically said at the end, let me just look here. She sought harm for violations of her search and seizure rights under the Nevada Constitution. We do not create a new cause of action. We recognize the long-standing legal principle that a right does not, as a practical matter, exist without a remedy of its enforcement, and that qualified immunity was a federal created doctrine, and states have their own sovereignty, and they don't waive their own sovereignty unless they want to, and they're basically saying, you know what, we think there ought to be a private right of action for this. This is the 51-page, one of the rulings the judge mentioned, and there's a lot to it here. Now, there were some things Chille said that, were kind of interesting, like, why don't you suck my rooster? The Castro requests I consider my order dismissing these claims. This is the federal judge. He asserts that he did back up in response to Bork's commands, and Bork did not tell him how far to back up, so Bork lacked probable cause to arrest him. He also argues that he had a clearly established right to film, so Bork's orders to back up and the subsequent detainment, search, and arrest violate clearly established law. Then there was supplemental briefing because Chille's convictions, both of them, got overturned. But the first amendment complaint alleged that when Bork initially told DeCastro to back up, he did. This is what Chille wrote in his pleading. But the FAC then alleged that when Bork told DeCastro to back up again, or Bork would detain him, DeCastro asserted his right to film the interaction, stating he had a right to be here, and continued to assert his rights. Given DeCastro's allegation that he had backed up for the first time, paired with his allegation that he was asserting his rights to stay where he was when Bork directed him to back up further, the FAC did not allege that DeCastro backed up again when ordered to do so. So there's already right there. This was it, game over at the appeal. In overturning DeCastro's obstruction conviction, the state court judge found that DeCastro did in fact back up when ordered to do so. Now, this is a conflict with the videotape and Chille's own pleading. Although the state court judge was applying a different standard than probable cause, and her finding does not reflect the only possible interpretation of the body cam video regarding DeCastro's compliance, it is a reasonable one. So this is an interesting tap dance that the federal judge is doing. He's saying, okay, state court judge, since this has already been done and I have no say in this now, that's state, I'm federal, I'll say that you were reasonable because I have to go along with it. I'm bound by your decision. Also, at the same time, I'm going to say it's not the only interpretation, though. Bork did not have the benefit of the decision at the time, so therefore, how could he be subjected to it? And it says here, however, a reasonable jury could find that Bork had probable cause to suspect that DeCastro violated the statute, even with this interpretation, because DeCastro refused to obey his orders to back up. So what do you want on this, guys? This is a federal judge who's gone through this with a fine-tooth comb, and you know what? He's really saying that the state court judge and him are not agreeing on this. And then I gave a lot of attention to the resisting arrest charge, and just like this judge is saying, no one else really wanted to talk about it. I sure as hell did. Anyway, given the finding, a reasonable jury could reach the same conclusion, although that is not the only reasonable view of the evidence. Consequently, even if Bork's initial detention of DeCastro was unlawful, the officers may still have probable cause to arrest DeCastro for resisting arrest. State court judge who also overturned his resisting arrest conduction. So anyway, because although DeCastro backed up a foot or two, a reasonable officer in Bork's shoes could have concluded that he did not back up in any meaningful way. Further, DeCastro communicated to Bork that he was not going to back up any further. So anyway, there's a lot more to this. I don't want to turn this into a long speech. Let's wait until the pleadings come out. There's going to be a lot to this case because there's a lot of facts that are being all wrapped together, including a trial and an appeal. And for me at this stage, I think what Chille needs to be looking at is preserving his rights to attorney's fees, because he's made enough to create trouble in a lot of areas. Now, the more factual it becomes, the more it favors him. The other side has to start looking at things as pure questions of law. When Agnes said this at the bail hearing, she was acting in advocacy. And the judge would say, as a matter of law, that's advocacy. That part of the complaint can be stricken. And you're going to have to start knocking things down a little at a time. Anyway, we'll wait and see. Hope all is well. And catch you on the next one.
Well, thanks once again to Patrick Darcy for giving an excellent analysis on this particular case for Chille de Castro. And what I really find interesting is that Chille is trying to sue people that actually helped him out in this scenario. So it really makes you wonder, is this guy trustworthy? Can you really trust Chille de Castro to do the right thing and help others out without screwing them over? And the answer is pretty much no, you can't really trust him in that regard because he's got a history of, well, being totally untrustworthy when it comes to fundraisers and dealing with tragic events. Now, I'm not going to name names, but it's out there. There are a lot of channels that deal strictly in delete laws BS claims. And with that being said, I hope you guys enjoyed the video. Thanks for watching, and I'll see you on the next one.
This could be some groundbreaking stuff right here.
You don't want to go to jail.
For what?
You read this.
I don't have to listen to
Read it.
anything. Blah, 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 blah.
Dude, so there's no way I can get in, bro? Come on, I'll put you on my YouTube.
But shut up, Wesley.
You gotta put signs up, ma'am, if it's...
Are you Glenn Serio?
Who's that?